Greetings, everyone. Today, I, Kumar Shapad, welcome you each and everyone at LegisNations Super 100 International Series of Arbitration webinar. And today with us, we have Jern-Fei Ng. He's a Queen's Counsel at Essex Court Chambers, and he's an experienced counsel specializing in commercial litigation and arbitration with 16 years experience appearing before courts and tribunals and sitting as arbitrator in different jurisdictions, including England, Hong Kong, Singapore, Malaysia, Cayman Islands, and Luxembourg. He's also described as having a blue chip practice litigation experience that is top class with encyclopedic knowledge of law, the most client friendly barrister at the English bar, and legally brilliant and can master complex facts easily. He can even eat documents for breakfast, is not afraid to get stuck in, and has a formidable reputation in Asia Pacific as an arbitrator and counsel, and is one of the youngest appointed Queen's Counsel in 2018. We welcome you, sir, and we are highly obliged that you are on board with us, and it's our honor to interview you. Thank you so much for joining us.
Well, Kumar and Arush, thank you so much for inviting me, and it's a pleasure, privilege, and honor to be on your webinar, and greetings to everyone who is watching.
Thank you so much, sir. So let's start with few questions, sir. As the world has come to a halt due to this pandemic, the learning has come to a steeper curve. So what has been your greatest learning from the pandemic, and where do you think we will find ourselves at the end of it?
Well, Kumar, thank you for the opening question. I think that's it's a good place to start, because obviously the world has changed as we know it. And at least so far as my area of work is concerned, which is commercial dispute resolution, I think the biggest learning item to emerge of all of this is the ability to master techniques of conducting hearings online, so virtual hearings, in other words. As they say, the necessity is the mother of invention. And as a result of the travel restrictions which have been imposed in a number of nations across the world as a result of the pandemic, the wheels of justice have not stopped turning for many of these jurisdictions. And instead of having in-person hearings, whether they be court hearings or arbitration hearings, have simply taken place online. So I think that's probably the biggest thing to learn and to master, which certainly I've learned and hopefully sought to master arising out of this pandemic, which is how to conduct efficiently virtual hearings. And in terms of where this will take us post-pandemic, I think the familiarity that we have as a community engendered or built so far as virtual hearings are concerned is here to stay. And there will be an increasing use of virtual hearings where there previously, pre-pandemic, hadn't yet been before. I don't think it will replace necessarily all forms of in-person hearings, but certainly there will be a greater willingness on the part of end users, arbitrators, and counsel alike to conduct hearings, particularly those which are perhaps shorter in duration, online, virtually. And what I predict is that this will also diminish simultaneously the frequency with which we have, say, telephone hearings, because obviously where you have the ability to, an inclination to conduct a non-in-person hearing, there is much to be said about conducting it virtually, where you can see and be seen by the other participants in the hearing, as opposed to conducting it via the telephone.
Right, sir. Right. So, Arush?
Right. Sir, So we as students always look for motivation. So what do you think motivated you to choose legal profession as a career?
Well, Arush, I think the truth is that I wasn't really all that sure as to what career I would want to choose when I was perhaps still in my secondary education. And it got to a stage where I had to choose, obviously, a subject to pursue at university. I wasn't very good with the sciences, and so I thought something perhaps in the arts would be more appropriate. And it was either history or law. And I think really what really appealed to me to study law and ultimately to pursue it as a career is the process of logical reasoning and deduction, firstly, that you get with the law as a subject. But particularly, so far as my line of work is concerned, is the ability to marshal the knowledge you have acquired about your subject matter, i.e. the law, and to use it as a tool to help your clients to present their case in the most favorable light. And obviously the ultimate objective is to secure a favorable outcome for your client. So is the ability to master the subject matter and then to use it as a tool to help your client achieve an objective is something which has always excited me, because it is certainly something which I enjoy doing, have done it for quite some time now. And that was really what piques my interest in firstly studying and then ultimately pursuing a career in the law.
Thank you, sir. Sir, as you are such an amazing barrister, and I mean, you are a role model to a lot of young aspirants like us who are doing law. So we just want to know that how can one master the three elements of advocacy? I mean, what to say, when to say, and how to say.
I think when to say, how to say advocacy, there are in fact sort of two types of advocacy in very broad terms. There is written advocacy and oral advocacy. So the question is when to say, how to say it, where to say it, etc. Are considerations which are to be brought to bear, whether you are considering written advocacy or oral advocacy. There are a lot of people perhaps who conceive of advocacy in very broad terms as being oral advocacy alone, or predominantly oral advocacy. And that is true to some extent, it is. But certainly in the line of work which I do, written advocacy is just as important. And in fact, it is an essential foundation on which you can build a good speech, i.e. oral advocacy, or pursue an effective line of cross-examination. Because through written advocacy, you get to inform your target audience, principally the judge, i.e. the court or your arbitrators, what exactly your case theory is and why you are right insofar as your case theory is concerned. That in turn sets the right frame of mind within which they will then consider and evaluate the persuasiveness of your oral submissions and or the line in which you take by way of cross-examination. So, to answer when you say it and where you say it, well, the truth is you should always deploy your best arguments also in your written advocacy, in the course of written advocacy, in as much in your oral advocacy. Now, how to say it, that's an interesting question. I think so far as written and oral advocacy is concerned, how to say it, well, I would say there are two key takeaways there. One is to aim to keep things as simple as possible rather than to make things unnecessarily complicated. There might be a temptation on the part of the lawyer, perhaps to make an argument sound as elaborate and complex as the case may be, because it might be thought wrongly, in my view, that is, that would signal to the court or to the tribunal that this is a clever argument. Look, it's very complicated, but I understand it. Rather, you are more likely to be able to carry the court or the tribunal with you if you can boil it down into simple concepts, simple propositions, which anyone can understand, layperson or judge or arbitrator. The most effective advocacy I have seen are the ones where they can boil down really complex cases, whether complex factually and or legally, into simple propositions, and to present their case in such a succinct way to the target audience. So that's the one key takeaway. The second key takeaway is that when you are, again, irrespective of whether you're embarking on written advocacy or oral advocacy, is to always set out from the outset, what is the overarching point you are making? And typically, I've got a rule of thumb that particularly when it comes to written advocacy, because that's the first time usually that the court or the tribunal will be engaging on all fours with the case as a whole, in particular your case as a whole, then you have to tell your audience from the very first paragraph what you are asking for and the reasons for asking for making that request. In other words, you must tell the court or the tribunal from the very first paragraph why you should win, and you do it very succinctly. It is a common error that the advocate waxes lyrical for many pages before they finally get to the punchline, and they explain what exactly it is they are asking for. And just as common is the error whereby they, again, it's many pages after perhaps they set out the facts, etc., before they explain in clear terms the reasons why they should win. There is nothing more frustrating to the decision maker, in other words, the judge or the arbitrator. And I sit as arbitrator as well, so I've got insight into this from the perspective not just as counsel, but also from the perspective of an arbitrator. There is nothing more frustrating than for someone who is called to make a decision, not to understand from the very start what exactly it is that the decision is that you want them to make. So always start from the very first paragraph explaining what it is that you want, why you should get it. Because once again, you've provided the arbitrator or the judge with that framework, it makes it so much easier than to follow the detailed submissions, which you will then go on to make in the rest of your written advocacy.
Right, sir. So, Arush?
Yes, sir.
From you?
Sir, how has been your experience being a QC, and if you have any experience to share with us, any intriguing story?
Well, Arush, the sort of work which I do is quite diverse, even though it's sort of broadly commercial in nature. And I appear in court in as much as I appear before arbitration tribunals, and I also sit as arbitrator. And the beauty of the work which I do is that it's also diverse in the sense that my clients, the teams I work with, come from different parts of the globe. And one day I could be appearing before a tribunal, an arbitration tribunal in Hong Kong. The next day I could be appearing before the commercial court in London. Or another day I could be in a meeting with clients strategizing about a potential acquisition they are going to make, say in Singapore for that matter. So there isn't really a typical day as such, certainly not in my line of work. So every day, but I think that's what makes it fresh and exciting. The fact that there are a varied array of different and diverse experiences which I encounter in the course of my work, and but I enjoy every one of it. There are every different type of experience since becoming a silk. Certainly, one thing which I've done a bit more of since becoming a silk or a Queen's Counsel is leading different teams into hearings as the lead counsel, and that's what I really enjoy. Sort of working with lawyers, juniors, solicitors, client representatives from different backgrounds, some of whom come from a common law background, and even those who come from civil law backgrounds too.
Right. So as adding to this particular point, as you have been to so many leading cases, VIT cases, commercial arbitrations, so what do you consider your greatest strength and your greatest achievement?
What I consider my greatest strength and greatest achievement is perhaps, trying to articulate for a client who comes from a different system to that by which their dispute is to be resolved, their case in as coherent a fashion as is possible. But by that, what I mean to say is that I think my greatest strength is really understanding people who come from different walks of life, different cultures, different backgrounds, different ways of doing business, and being able to explain their viewpoint to perhaps a tribunal or a court who may not necessarily be as familiar with the way in which my clients do business, and likewise being able to translate what might otherwise be difficult concepts of English law to explain to my lay clients, ordinary business people who might not otherwise have the legal knowledge that lawyers and those who are legally qualified do, and giving them the sort of comfort of knowing that the process, even though it's one which is unfamiliar to them, In fact, it's a logical one in which they can ultimately prevail, so long as, of course, they instruct the right lawyer and marshal all the right arguments.
Okay. Arush?
Okay, so we have heard a new term, dispute prevention, which the state to state is allowed, but an investor can't bring in a claim against the state. What do you think this will become a new format for treaties between nations going forward?
Well, Arush, I have to say, I haven't come across that before. Dispute prevention in the sense that only state-to-state claims will be allowed. Certainly what I have heard or what I have read about is the idea that instead of having investor-state disputes being resolved by arbitration, by way of arbitration, instead to have them resolved by permanent investment courts. And that's what I have heard. And there are obviously pros and cons to this, but ultimately there is much to be said about the system of arbitration as a means of resolving disputes, whether they are commercial disputes or they are investment disputes. The ability, obviously, to choose, to select, or to nominate an arbitrator is something which a lot of parties to arbitration treasure as being a fundamental feature of arbitration. Again, whether it's commercial arbitration, investment arbitration that they like. The fact that there is already an existing framework, namely the New York Convention, pursuant to which arbitration awards can be easily recognized and enforced. So, so far as recent developments are concerned, dispute prevention is something I've not really encountered, or I've not encountered. But certainly, I know that there's a raging debate whether or not investment disputes should be resolved by way of arbitration as opposed to by way of a permanent investment court. And I think there is much to be said about keeping the system as it is. Of course, there's always room for improvement. But as they say, you shouldn't throw the baby out with the bathwater, to the extent that there are aspects of the present system that can be tweaked, and no doubt they can be. Then there is much to be said about preserving the present system for resolving investment disputes.
Right, sir. So going back to what different government across the world have done in response to the COVID-19 situation, sir, there have been some unprecedented measures, and in fact, the level of state intervention into private rights, it is also quite unparalleled. So do you think this will find a way to bilateral investment treaty claims?
Not only do I think that it will find a way, or rather that it will translate into investment treaty claims, whether they are bilateral or otherwise. In fact, they have already, at least in some instances, translated into actual or threatened investment treaty claims. So it's not just, it's no longer theoretical, it has occurred. But I think the burning question is whether or not such claims will ultimately prevail. And I think it really depends on a case-by-case basis. It's difficult to generalize and say whether or not COVID-19 related measures which are adopted in state A, which are targeted at industry X, is necessarily more justifiable than, say, measures which are introduced by state B targeting industry Y. So I think it all turns on the facts of each case, but there is certainly conceptually nothing that prevents the possibility of such measures being the subject of disputes, at least in the investment sphere.
Okay. Yes, Arush, please.
Okay, sir. Sir, anything from litigation that you feel that any feature that can be brought to international arbitration that could really change the efficiency of international arbitration?
Well, Arush, I think the premise of the question rests on the notion that there are features in litigation which are not currently present in arbitration. But to my mind, I don't think that there are really any such features of litigation which are materially missing from arbitration. Because the whole point about arbitration is that it is a platform pursuant to which procedural flexibility is the order of the day. The tribunal has got very broad procedural powers, master of its own procedure, and can fashion, within reason, of course, such procedures as are necessary, reasonable, and proportionate to meet the needs of any particular case. Thus, I'm not sure that there is really anything as such, as far as litigation is concerned, that isn't currently available in arbitration that needs necessarily be transferred or imported across. However, having said that, I do think that one of the things that perhaps is lacking in the context of arbitration, but is perhaps more present in the context of court-based litigation, is the resolve on the part of arbitration tribunals to crack the whip when it comes to procedural inefficiencies or procedural dilatoriness, for fear, and this is what I think some commentators have described as due process paranoia, whereby tribunals in general, and I suppose it's dangerous to generalize because there are as many different approaches out there as there are different arbitrators, but that anyway, for what it is worth, generally there is a perception that perhaps in general, arbitral tribunals may be less willing to crack the whip with delinquent parties when it comes to procedural inefficiencies, as opposed to a court, for fear that this might be regarded in due course as otherwise as a basis for challenging recognition or enforcement of the award or on due process grounds. So if there is something that I would change, and it's not really a change thing, but it's really ensuring that arbitral tribunals know and giving them the platform on which they can perhaps take more assertive approaches in ensuring that all parties toe the line procedurally without necessarily fearing that this would give rise to due process related challenges in due course.
Right, sir. So anything, any general strategies you would advise young practitioners who want to position themselves strong career in international arbitration to take, whether as a counsel or as an arbitrator, like even I aspire to be on the position of an arbitrator or a counsel doing an international arbitration. So what all are the strategies you want to advise or you want to suggest us?
Well, I think if you are interested in pursuing a career in international arbitration, certainly there is much to be said about, if it's available, of course, in the countries in which you are, in the country or countries in which you are living in or studying in, is obviously to pursue a specialist course in arbitration. Some universities offer it as a subject at the undergraduate level. More commonly is that it is offered perhaps as a subject or entirely as a course to be pursued in the course of a postgraduate degree. So that's a very good way of acquiring knowledge about the subject matter. Another way is to seek out opportunities, perhaps to shadow, to intern, or to act as secretary to arbitrators or arbitration tribunals.
Thank you, sir.
Okay, sir. So what does it take to be a Queen's Counsel?
Well, the concept of a Queen's Counsel, Arush, is one is a person who is recognized as possessing excellent advocacy skills, and the process is quite in order to get that sort of badge of honor. It is actually quite an involved process in terms of the application that has to be undertaken. There is a very detailed application form that you have to complete, and you have to name a considerable number of assessors or referees from amongst the judiciary, other practitioners, as well as clients. And those who are shortlisted will then attend an interview, which lasts from about 40 minutes to an hour before you are ultimately named as Queen's Counsel. But you've got to fulfill certain requirements or certain competencies, and one of which is being able to use and understand the law. Second is obviously your written advocacy, Third is oral advocacy. Also just as important is your ability to work with others. And last but not least is your ability, obviously, to promote diversity. And so these are all very important competencies which together are used to evaluate the suitability of a candidate for appointment as Queen's Counsel.
Right, sir.
Okay.
So moving forward, so would you like to say a few words about some of the greatest losses in your legal career?
Well, I think that's an interesting concept, a loss. I think I get asked, the question which I get asked a lot is, how many cases have you won and how many cases have you lost, etc. So what is your win-loss ratio? I think, however, that perhaps oversimplifies matters. Very often, when I get instructed on a case, there isn't necessarily a clearly defined objective whereby you have, it's very clear, what is, that if you win the case, then that is a win as far as the client is concerned. Sometimes the case that you are presented with is one whereby what the client really wants to do is that maybe they know that they are, on a difficult position so far as liability is concerned, and really what they want you to do is to reduce your damages. But I think some of the most humbling losses that I've encountered, the yardsticks notwithstanding, really are ones which have come fairly early on in my career. I remember in particular there was this hearing which I had, in which I was representing a credit card company, and I appeared before a county court in some far-flung location in the southeast of England, which I now cannot remember where it is. And I was, the object was to try and get orders to recover the debt, the credit card debt that was owed by the defendant. And the defendant, as it turns out, was unemployed and therefore a litigant in person. And the reason why she was unemployed was because she had been dismissed from her previous job, which, as it happens, was a job with the same credit card company. So you can imagine the predicament I was in. And I remember that I thought that the way of smoothing things over with the judge would be to at least express a few words of sympathy for the client, for the other side's position. So I started by saying to the court that, on behalf of my client, we are sympathetic to the predicament that the defendant finds herself, but a debt is a debt and it must be paid. To which the judge said to me, says, "Oh, Mr. Ng, any tears you or your clients shed for the defendant are but crocodile tears, and that you're just here for a pound of a flesh, aren't you?" I mean, my instinctive response was to say, "Yes, what's your point?" I thought the better of it. It was a rough hearing, or obviously bruising indeed, but you know what? I think it's really hearings like that whereby you get you are on the receiving end of rough treatment from the court. So that really allows you to grow as an advocate, because no two cases are alike. Some cases will be easier to litigate than others. There are other cases where really it's an uphill struggle. But and this is a salutary lesson to all the young advocates or budding advocates out there, don't be disheartened when you do encounter difficult situations like the one I encountered many years ago when I was a junior, in which, in fact, I didn't lose the case. I won it ultimately, but it wasn't after that slightly horrific hearing that I went through. But use it as a learning experience, obviously, in order to grow as an advocate. And so that was, in a sense, it was a loss, not in terms of the outcome, but it was a loss in the sense of the experience or the process that I went through. But looking back now with the benefit of hindsight, I think it helped me as an advocate, and I am glad that I did encounter a slightly irascible judge in those circumstances, because it certainly turned out to be an invaluable learning exercise.
Thank you so much, sir, for your answers and for your such enlightening experiences, such enriching experiences you told us. And your words are something which will enlighten a lot of law students, law aspirants who wish to have something in the law field or the legal career, who wish to achieve some great heights in the legal field. And it is our honor that you associated with LegisNations and with us, and you took out your precious time to get interviewed with us, and it is our honor to interview you, sir. Thank you again for joining us, sir. Do you wish to
Kumar
speak?
and Arush,
Yes,
thank
sir.
you so
So
much for
moreover,
having me.
yes, sir. So moreover, we even got inspired personally while conducting this interview. So it was a really great session.
Well, thank you. That's very kind of you. It's a real pleasure to be able to do this webinar with you all. And I wish you both and everyone else who is watching this webinar every bit of success in your future career aspirations, and stay safe and healthy.
Thank you so much, sir.